the respondents as well. You have 20 minutes to speak. The judges do have 2 extra minutes that we may allocate. However, we will use our discretion to provide that on the basis whether it is necessary or not. My 2 justices can also speak to you about how they prefer to ask their questions. So I don't know if they prefer to ask their questions as you present, or if they prefer to ask their questions at the end. Kindly please advise on that.
Thank you very much, Judge Toga. This is Judge Soma right now. I will be asking my questions while everyone is presenting their arguments before the court.
Okay. Applicants, respondents, you heard that?
Yes, we did.
Thank you very much.
Yes, we did.
Justice Ramanyimi?
I'll ask my questions after.
Okay, excellent. I think we can begin unless the applicants and the respondents have any questions regarding the overall proceedings. Any questions? Applicants, you may begin.
Okay, we're having a problem with the video.
Okay.
We have switched it on, but then we cannot see ourselves on the screen.
We can see you, so I think you may proceed. It's fine.
Okay, excellent.
Good morning, Honorable Justice. My name is Nobuhle Tiko, and I'm here with my co-counsel, Lesotho China, on my left-hand side, who will be representing the applicant. We humbly approach the court today to raise 3 issues: learners' right to privacy, suspension of the 6 learners, and denying them their right to peaceful assembly. We'll use the Constitution, South African Schools Act, case laws, and facts to prove that the decision taken by the school was unconstitutional. We hereby stand in favor of the applicant whose rights were violated by the respondent, Njodolo Combined School. We submit that Section 4 of the school's code of conduct is unconstitutional and it violates the learner's right to privacy and a basic education in terms of Section 14 and 29 of Section 1A of the Constitution. Also submit that the SGP's decision to suspend the 6 learners violates their right to basic education in terms of Section 29 of Section 1A of the Constitution. We argue that Section 4 of the school's code of conduct is unconstitutional and it violates the learner's right to privacy and a basic education in terms of Section 14 and 29 of Section 1A of the Constitution. Searching the learner's facts, confiscating their cell phones, and suspending them as unconstitutional and is in violation of Section 14 of the Constitution, which states that everyone has the right to privacy, which include not to have subsection A, their persons or home search, subsection B, their property search, subsection C, their possession seized, and subsection D, their privacy of communication infringed. No one has the right to invade in anyone's privacy. A person acts with criminal capacity if he or she intrudes in anyone's privacy. The 4th Amendment of the Constitutional Privacy Rights states that everyone has the right to be secure in their own spaces, papers, homes, and defense against unreasonable searches. Cognizant of Section 36 and Section 1E of the Constitution states that the rights in the Bill of Rights may be limited only in terms of the law general application to extend that the limitation is reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom, taking into account all the relevant factors, including subsection E. Less restrictive means to achieve the purpose. It is our submission that Section 4 of the school's code of conduct pressures us too harshly on a punishment and does not reflect on the objective of the Constitution. The school could have used positive disciplinary measures. Remember, the aim should be to discipline the learners and not punish them. Some teachers still use this corporal punishment, which is in violation of Section 10 of the Constitution, which states that everyone has inherent dignity and has the right to have their dignity respected and protected. Research shows that corporal punishment at schools is not an effective practice and can cause more harm than good. Children who are beaten and abused are more likely to be prone to depression, low self-esteem, suicide, and drop out of school. Corporal punishment also violated Section 10, Subsection 1 and 2 of the South African Schools Act 84 of 1996, which states that no person may administer corporal punishment at schools, and Subsection 2, which states that any person who contravenes Subsection 1 is guilty of an offense and liable on conviction to a sentence which could be imposed for assault. Section 10 Section 10 of the Constitution is protected entirely by the Constitution, even during the state of emergency. We further assert that the Archbishop to suspend the 6 learners violates their right to basic education in Section 29 of Section 1A of the Constitution. The case of Feathers versus MEC of Education, Gauteng, 2016, in paragraph 3, emphasizes this by stating that everyone has a right to a basic education, including adult basic education. Suspending the 6 learners for the rest of the year is in violation of the state. The children's right to a basic education was denied. Decision to suspend also violated Section 28, Subsection 2 of the Constitution, which states that a child's best interests are of paramount importance in every matter concerning the child. The children's best interest lies with them being at school. Moreover, the decision to suspend the 6 learners from school for the rest of the year also violated Section 9, Subsection 1A of the South African Schools Act 84 of 1996, which states that, subject to this act and any provincial law, a school governing body of a public school may, after a fair hearing, suspend a learner from attending school as a correctional measure for a period not longer than 1 week. The learners did not undergo a disciplinary hearing before their suspension. Honorable Justice, I'll kindly like to hand over to my co-counsel to continue with the argument. Thank you.
Good morning, Honorable Justice. And in addition to what my co-counsel said, we also argue that Section 17 of the Constitution, which says that everyone has the right, peacefully and unarmed, to assemble, to demonstrate, to picket, and to present petitions, was violated. The police told the learners that their protest was illegal and ordered them to leave the scene, whereas one of the learners indicated that the protest took place spontaneously. And Section 12, Subsection 2 of the Gatherings Act, number 205 of 1993, states that it shall be a defense to a charge of convening a gathering in contravention of Subsection 1A that the gathering consent took place spontaneously. United Nations International Covenant on Civil and Political Rights, Article 21, states that the right to peaceful assembly shall be recognized. No restrictions may be placed on the exercise of this right other than those imposed in conformity with the law and which are necessary in a democratic society in the interests of national security or public safety, public order, the protection of the rights and freedoms of others, or the protection of public health or morals. The 6 learners' right to peaceful assembly, as stated in Article 21, was denied.
Pardon, Counsel, I just have a question, pardon, and I think perhaps this might be more directed towards the first speaker, but any kind of limitation on the right, as you've already stated, the limitation on the right to basic education and privacy and so forth, it has to be justifiable in terms of Section 36 of the Constitution. Wouldn't you argue, or at least I would argue, that this limitation was quite justifiable? Especially considering the circumstances of the school, considering the academic regression that was taking place, I would say that the limitation that was placed on the basic education of these kids was actually justifiable. Can you please respond to that?
Can you please rephrase the question?
Yes, I will. Yes, I will. I will just rephrase the question. So I was saying that any kind of limitation on a constitutional right is subject to Section 36 of the Constitution, right? Now, I would argue that Section 4 of the School Code is actually justifiable, a justifiable limitation in terms of Section 36 of the Constitution. So I'm actually saying that it is right to limit that constitutional right. Could you please respond to that?
Honorable Justice, in response to your question, I'd say the limitation constitutes an unreasonable limitation to the rights of the learners in terms of Section 36, subsection 1E of the Constitution, which states that the rights in the Bill of Rights may be limited only in terms of law general application to the extent that the limitation is reasonable and justifiable in an open and democratic society based on human dignity and equality. I'd say subsection E states that they use less restrictive means to achieve the purpose. So the school governing body, by suspending the 6 learners for the rest of the year, violated this subsection 1 because it used a very harsh method of trying to instill discipline in learners. It was too harsh.
Thank you very much. You may proceed.
On both occasions when there was a fire on the school premises, there were no culprits identified on the scene. The importance of the right to go out and assemble with others was further demonstrated in the case of Setawu and Another versus Gavas and others in 2013 in the Constitutional Court. Gavas case, paragraph 52 states that everyone who is unarmed has the right to go out and assemble with others to demonstrate, to picket, and to present petitions to others for any lawful purpose. Moreover, even our democracy was achieved through assembling and demonstrating peacefully. United Nations Convention on the Rights of Children, Article 15, Sub-Article 1 states that states parties recognize the rights of the child to freedom of association and to freedom of peaceful assembly. This means that international law also protects the rights of the child to freedom of association and to freedom of peaceful demonstration. Moreover, paragraph 61 emphasizes this by stating that the right to freedom of assembly is central to our constitutional democracy. It exists primarily to give a voice to the powerless. This includes groups that do not have economic or political power and other vulnerable persons. It provides an outlet for their frustrations. This right will in many cases be the only mechanism available for them to express their legitimate concerns. This means that the Constitution protects the vulnerable groups such as the 6 learners. In conclusion, the applicants contend the decision taken by the SGB under the above reasons. The applicant also petitioned this honorable court to find in their favor and rule Section 4 of the School's Code of Conduct unconstitutional since it violates the learner's right to privacy and a basic education in terms of Sections 14 and 29 of the Constitution. They were denied. The applicant also praised to this court to rule in their favor since the SGB's decision to suspend them violates their right to a basic education in terms of Section 29, subsection 1A of the Constitution. These 6 learners were denied their fundamental right to a basic education. Section 28, subsection 2 of the South African Constitution states that a child's best interests are of paramount importance in every matter concerning the child. Section 8, subsection 5 of the South African Schools Act, number 84 of 1996, states that a code of conduct must contain provisions of due process, safeguarding the interest of the learner and any other party involved in disciplinary proceedings. And in this case, the children's best interest lies with them being at school and receiving their education. The Constitution is the supreme law of the land. No legislation can contravene the Constitution. If any of legislation is enacted and it does not have the consensus with the Constitution, that legislation is unconstitutional. I thank you, Honorable Court.
Thank you very much, applicants. Justice Ramanyimi, do you have any questions?
Firstly, just before I ask my question, can I just get the names of the applicants' representatives? I didn't get and the spellings, please.
The first speaker is Nobuhle Tiko, and the second speaker is Lisiro Chishai.
Nobuhle, can you spell Diko?
D-I-K-O. D-I-K-O.
Okay, and the next one?
Lisiro Chishai.
Can you spell
L-E-C-T-O.
L-E-S?
L-E-C-S.
L-E-S-E-G-O.
Okay, all right. Thank you.
Please spell your surname, sir.
C-H-O.
C-H-O.
S-H-A.
S-H-A.
N.
M.
N-E.
M-E. Oh, Choshame. Okay. Yes. Any questions from Justice Ramanyimi?
Yes, I have a question. Could you please let me know whether you think Section 4 of the Code of Conduct is unconstitutional in its entirety or maybe in parts of it? And if maybe there's room to expand it to make it, how would you expand it to make it constitutional? If your answer is that it's unconstitutional.
Can you
Should I repeat? Yes. Do you think that Section 4 of the Code of Conduct is unconstitutional entirely? The whole section is unconstitutional entirely, or maybe only sections of it is unconstitutional? And if it's only sections of it, could you please maybe expand what you would do to make it, or what it should say to make it constitutional?
Okay, thank you.
Okay, before you answer applicants, I didn't hear you reserving any time for your rebuttal. So you still have 4 minutes, 30 seconds to answer any questions that we're going to have.
The whole provisions of Section 4 of General Combined School Code of Conduct are unconstitutional in terms of Section 36, subsection 1E of the Constitution, because it projects too harshly on the punishment, and also it violates the learner's right to privacy and a basic education. Because in terms of Section 9, subsection 1A of the Constitution, which states that in terms of Section 9, subsection 1A of the South African Schools Act, number 84 of 1996, it is stated that subject to this act and any applicable provincial law, the governing body of a public school may, after a fair hearing, suspend a learner from attending a school as a disciplinary measure for a period not longer than 1 week. And the period of a year actually exceeds a period of 1 week, as stated in Section 9, subsection 1A of the South African Schools Act, number 84 of 1996.
Thank you very much, Mr. Choshame. So I have a question for you. Actually, before I proceed, let me ask Justice Ramanyimi whether or not she's satisfied and whether she has any follow-up questions for you.
That was the only question, Justice Toka. Thank you.
Thank you very much. So, Ms. Diko, Mr. Choshame, I'm looking at these facts and I'm looking at paragraph 5 on page 3 of the facts, right? So it simply states that the next morning learners arrive at school as usual, but now approximately 100 learners convene outside the gate with posters saying it's cause of causa and all of that. And essentially school did not start that day. So we spoke at length about the right to education. We also spoke at length about freedom of assembly. How do we balance those two rights, which seem to be fighting each other in this particular set of facts? Is one more important than the other? Is the freedom of assembly more important than the right of children to receive an education? Is there a way to limit this freedom of assembly in a way that it does not impede on the right of education for other children?
Majority does, but we cannot, the Constitution is supposed to be protecting all the citizens of South Africa to ensure that they get entitled to their rightful right, as stated in the Bill of Rights. So we cannot just make an exception just because it is a minimum group of 6 learners. So I think that we think that it is right for the other learners to assemble in order for them to have their voice heard.
I understand you, sir. But my question is then, yes, we spoke of the right to assembly. As you are saying now, we spoke of the right to education. Remember, one person's exercise of their rights should not impede on the other person's right, right? So in this particular context, we have a bunch of learners blocking other learners from being able to access their right to education because they feel that they want to protest. So I'm saying, to what extent is this justifiable? I heard you speak about a majority rule situation, but in our South African Constitution, the Constitution makes sure that everybody is protected, whether you're the majority or the minority. So in this particular context, the children who want to be able to go to school, who want to be able to access the premises of the school and are being blocked by the protesters, how do we deal with that? How do we balance that?
Thank you.
I'm going to give you 2 additional minutes because our 20 minutes has run out. I'm just going to give you 2 additional minutes to respond to this particular question.
Thank you, Chester. So answering your question, yes, peaceful assembly and the right to basic education, there are two of them that are important because the other children who are assembling, they're not assembling for themselves only, but they're assembling for others who will be then violated, who then their rights being violated by the school after them. Because we don't only speak for ourselves, but we speak for themselves, because we never know that tomorrow there will be the ones whose rights will be violated by the school also. So we're not denying them their rights, but we are also fighting for their rights. They have to be supportive of us and rule with us or side with us, because even we are fighting for our right to a basic education, which was violated by the respondent, which are the school. So we're not fighting for our rights only, but we're fighting for their rights. We're not denying them their rights to a basic education. We also consider it because we're thinking for them, what if this happens to them tomorrow, and there will be anything that we do, because they will see that our situation, we only fought for ourselves and we didn't consider themselves. So we're fighting for themselves so that they can speak for themselves too. So that they can have a voice to speak themselves and side with us.
Can I just disturb you quickly? We have 1 more minute, but I just need you to, whether you answer this or not is immaterial to me. I just need you to let it swim around in your head for future courtrooms. Remember, these children, these 100 children who are protesting, and you're saying that they're protesting on behalf of all these other children. These other children did not come together in a committee and elect them to do this. These other children could very well be saying, now my phone is at home, I want to be able to get into the class and I want to learn. I don't know why these other people are wasting my time. So please think about how, in a practical scenario, this could have been achieved, balancing both the right to basic education and freedom of assembly. For now, I'd just like to thank you very much for your participation, and I want to call on the respondents to make their arguments. Thank you very much, applicants. Respondent team.
As the court may please. Justice, can you begin?
Yes, kindly do. Would it be possible for you to stand up or bring your camera a bit lower, so that I can see maybe the top half of your body, or will the person speaking stand up?
Yes. Is it good?
Yeah, that's good.
Yes. Thank you.
Kindly present yourselves.
As the court may please.
Kindly present yourself.
Justices, I am Mande Sasitole, alongside is my co-counsel Simone Azande. We appear on behalf of the respondent.
Please recite your names again. I'm sorry. For the judges, please recite your names quite slowly so that we can record them.
I am Mande Sasitole.
Mandi Sasitole. Yes.
Alongside is my co-counsel Similani Azande.
Similani Azane.
Azande.
Please spell that Azane for me.
Yes. Azande.
Azande.
It's
Azande.
Yes.
Okay. Okay. So the rules that applied to the previous team also apply to you. I'm going to give you 20 minutes. You can decide how you chop and change that between yourselves. I assume that the rules relating to, or the preferences relating to the asking of questions by Justice Somo and Justice Ramanyimi remain. Yeah, you may proceed.
As the court may please, justices. I am Mande Sasitole, alongside with my co-counsel Simelane Azande. We appear on behalf of the applicant, of the respondent. I will present my arguments for the first 10 minutes, and the remaining 10 minutes will be used by my co-counsel. Justices, there is an argument presented by the applicant that Section 4 of the School's Code of Conduct is unconstitutional, while the implementation of this policy considered an adequate consultative process amongst teachers and parents. Justices, allow me to declare that the policy is rational because it was not causing any infringement to the process of teaching and learning. On such basis, I'm confident to say that it was based on reasons rather than emotions. Presented to the court is a case about the controversial matter between 6 learners of Mjondolo Combined School and the school itself. According to the nature of this case, the applicant is the 6 learners, whereas the school is the respondent. Justices, it is clear that according to the nature of this case, of this caliber, both sides, which are applicant and the respondent, have the constitutional support. But I'll focus on the respondent side. Justices, the arrival of Ms. Koza in January 2019 as the new principal left her under real pressure of instilling discipline back to the school, which have lacked a long period of time. I would like to refer this court into a matter between Anthony versus the governing body of Sections High School. In the year 2002, and was a constitutional court case, where the constitutional court stated that the question should be asked is in this regard, is whether or not prohibition is aimed at promoting discipline and whether or not non-compliance justifies punishment or other forms of sanctions. The role of Ms. Koza in this situation was to develop and come with decisive initiative in this situation. According to Section 8 of the South African Schools Act, on this occasion, it promotes that the governing body of a public school must adopt a code of conduct for the control and supervision of the processes of teaching and learning. The description and elaboration of this case declared that the 6 learners of Mjondolo Combined School who were suspended at school due to the failure to obey their school's code of conduct were guilty for convening an illegal gathering in respect of which no proper or adequate precaution given in accordance with these provisions of this section. Section 3 of Offences and Penalties Act. Failure to comply with the provisions of this section shall be guilty of an offense, and no conviction liable to a fine, imprisonment for a period not exceeding 1 year, both to the fine and imprisonment. Furthermore, Justice, in terms of Section 3 of the Gatherings Act states that a convener of a gathering shall give notice in writing signed by him or her for the intended gathering in accordance with the provision of this section. Justices, if I may refer you to a matter between Mulungwana and others versus the states and others in year 2019.
Pardon, counsel, if I may just interrupt you. I just have a question. Wouldn't you say that perhaps Section 4 is too broad of a rule? Because this provision, at least how it's been applied by the school, is in one instance, it seems like there is a disciplinary process that takes place. But then in the other instance, for instance, on page 2 of the set of facts, it indicates that a learner was immediately suspended. So it seems like there is no set procedure for students to actually know to what extent this rule will be enforced by the school. It seems like the school can actually just enforce it however they like. Wouldn't you agree with that?
Yes, I do agree with you. But it was due to the intervening event after the 6 learners were suspended to school and after their phones were confiscated. I don't know whether I'm here.
Hi, sorry. So then wouldn't that mean that the school can essentially decide under what circumstances and to what extent they are going to enforce this particular rule? Shouldn't it, to some extent, have some kind of limitations so that school learners can have certainty as regards to the provisions of this rule?
Justice, I do not argue what you are stating right now. What I argue is that since the school's code of conduct was taken into consideration and after a consultative process, meaning the framing and the implementation of this policy was the good one, because the parents and the representative of the learners were there and the teachers were also there, meaning that everyone is informed and well informed about the rules that are included in this code of conduct in that regard.
Thank you very much.
Yes. Furthermore, in terms of Section 3 of the Gatherings Act, it states that the convener of a gathering shall give notice in writing signed by him or her to the intended gathering in accordance with the provisions of this section. Justice, if I may refer you into a matter between Mulungwana and others versus the states, year 2019, and was also a constitutional court case. Paragraph 16, it is stated that if a gathering proceeds without formal notice, that can lead to a criminal offense. Now, giving deeper analysis into this matter, the suspended learners coming together collaboratively, it was not only breaking the rules of Section 12, subsection 1, but even the road users where they were burning the rubbish bins were interrupted. Their protest even violated the learners' right to basic education as they blocked the gate of the schools for any entry or exit within the school. So, Justice, according to the set of facts, it is stated that on page 3, paragraph 4, that these learners blocked the gate and it became difficult or impossible for non-striking learners to gain access to the gates. Most joined in or went home, and the school was eventually closed. Therefore, the school was justified in limiting applicants' rights in terms of Section 17 and 29 of the Constitution. In terms of Section 36 of the Constitution, it states that the following relevant factors must be taken into consideration, which are, firstly, nature and extent of the limitation. Secondly, the relation between the limitation and its purpose. Lastly, less restrictive means to achieve the purpose. Therefore, the school was justified to limit the applicant's right because they wanted to protect other learners' rights who were not willing to participate in this protest. The right which I'm talking to is the right to education. I would also like to refer this court into a case between Dladla versus the City of Johannesburg in year 2018, and was also a constitutional court case, where in paragraph 60, the court stated that for the limitation to be justifiable under section 36 of the Constitution, they must first and foremost be authorized by a law of general application, and this is the test which must be met, and any justification analysis may begin. Ultimately, in terms of section 4 of the School's Code of Conduct, we submit that it is not unconstitutional and does not violate the learner's right to privacy and basic education in terms of section 14 and 29 of the Constitution. When a code of conduct was, yes, sir.
Counsel, pardon, just to interrupt. Counsel for the applicant just argued that there are less restrictive means to enforce this particular form of discipline in the school. Can you please just elaborate and briefly just explain to us how there isn't any kind of a less restrictive means to enforce this rule?
Thank you, Justice. On that regard, the counsel for the applicants was on the means of putting it to the court that the school should have confiscated their cell phone only, but not furthermore suspend them, which in this extent was not possible due to the intervening event of the gathering that was unlawful, which was perpetrated by the applicant. I don't know whether do I make sense, Justice.
No, counsel, I don't believe you've answered my question. So my question is, the applicant just argued that there are less restrictive means to enforce discipline in the school. So measures that are perhaps less punitive than the ones that are currently being enforced. Now, you are currently arguing that no, these are the appropriate amount of measures, and for that reason, it is not unconstitutional and does not go against section 36(1)(e) of the Constitution. Kindly elaborate precisely how it is not, or kindly elaborate how there are no other less restrictive means, because taking someone's phone, that's a very simple thing to do, but to take someone's phone and then suspend them, that's quite a harsh punishment, especially in light of the fact that you're dealing with underage pupils. You want to ensure that they have the right to basic education. So are there no other means where perhaps you can just take their phone and enforce discipline in another way?
Thank you, Justice, for your elaboration to your question. If you can go deeper to the set of facts, it is stated that Mjondolo Combined School was not just a normal functioning school, but there were much resistance and much chaos taking place in the school, including the possession of cell phones during class, which took the attention of the learners in their subjects. I mean, a high level of chaos and a high level of non-concentrating learners was very high in this extent. So it's needed an implementation of a policy which is going to restrict all the negative acts that are perpetrated by learners in this extent, Justice.
Thank you very much.
Yes.
Thank you very much, Counsel.
Should I proceed?
Please do.
Please.
Yes. In terms of section 4 of the schools, ultimately, in terms of section 4 of the School's Code of Conduct, we submit that it is not unconstitutional and does not violate the learner's right to privacy and basic education in terms of section 14 and 29 of the Constitution. Because when a Code of Conduct was established, it was after a consultative process whereby the SGB decided to introduce a Code of Conduct regulating the use of cell phones at school, of which the learners did not manage to comply with the provisions of that regulation, which consequentially resulted in the application of this Code of Conduct.
There is no indication in the set of facts that the school learners were actually involved in this consultative process. So wouldn't you say that the act of the act of protesting was a way for them to feel heard and for them to raise their voices.
Justice, I hear your question. Yes, it is permissible for them to gather and to show their discomfort against the school, but the manner in which they are gathering was acted is totally unlawful, because it shows that on the side of facts, no notice was given to the school as to whether, why and when are they going to gather with their protest. Justice, I don't know whether I am here.
You may proceed, counsel. Thank you.
Thank you, Justice. So the regulation which consequentially resulted in the application of this code of conduct to those failing to honor it. Justices, as a representative of the respondent, I therefore anticipate a decisive measure of indemnification of the code of conduct of the 6 learners from the court due to them failing to embrace their school's code of conduct and misusing their right to assembly. Justice, if there are no any further questions, that was the end of my arguments. May I hand over to my learned co-counsel? I thank you.
Please do.
If it may please the court, I am Azadeh Smelane, and I'll furthermore argue on the 3rd and the 4th issue presented before the court. Counsel for the respondent submits that the learner's rights to education was not infringed. Furthermore, counsel for the respondent also submits that the learner's rights to privacy was not infringed. Justices, Section 4 of the school's code of conduct stated that if you are found with a cell phone, it will be confiscated and you may be suspended. The code of conduct spells out the rules regarding learners' behavior, at which the school describes the disciplinary system to the implementation by the school concerning the transgression by the learners. Now, your justices, the first learner who was suspended from the school underwent a disciplinary hearing. A disciplinary hearing at a school is basically an opportunity for the learner to justify his or her actions. I would like to bring it to the court's attention that Sfiso Cele failed to justify his actions for bringing his cell phones to school, leading to his suspension. Right after Sfiso Cele's suspension, as stated on the set of facts, paragraph 5, that Ms. Khoza issues a warning after the suspension of Sfiso Cele. But, Your Justice, the learner's resistance to the fellow code of conduct, even after a warning was issued. Furthermore, reasons to other learners not being afforded a disciplinary hearing was due to the intervening acts and incidents that occurred.
Miss Azande, I'm going to disturb you pretty quickly. We have 4 minutes remaining, so just, keep that in mind.
Yes. Your Justice submits that the learner's rights to privacy was infringed because according to Section 8A, Subsection 2, random searches and seizure and drug testing at schools. School submits that Subsection 3, the principal or his or her delegates may at random search any group of learners or the property of the group of learners for any dangerous objects or illegal drugs, if a fair or reasonable suspicion has been established. A search contemplated in subsection 2 may only be conducted after taking into account all the relevant factors, including the best interest of the learners in question or any other learner in the school. In this case, Your Justice, the random search was after the best interest of other learners at the school to keep discipline and order. The learners who did not bring their cell phones to school were complying to the school rules.
Schools authority do not meet any consent of the learners in order to conduct a search. Another point I'd like to bring to the attention of the courts is, after deep research, I have found schools do have the right to search students' backpacks, but only under certain circumstances. Firstly, your school has to meet a reasonable suspicion that search you will turn up evidence that you violated a school law or rule. And in this case, a reasonable suspicion is Fisokele's case. And during the search, the school did find cell phone, which violated the school's code of conduct, section 4. Secondly, the way of the school does its search should be reasonable based on what is being searched and your age. Your Justice, the school was searching for cell phones and nothing else that violated their privacy. According to section 36B, the reason as to why the learner's rights to privacy was limited is because the school still wanted discipline amongst the learners and to keep order. Also, in terms of section 36, it was justified, as the learner's conduct infringed other learners' rights to basic education, as stated in section 29.
2 minutes, Council, 2 minutes.
Yes. Your Justice, can we please have 2 minutes edits to our time, if it may please the courts?
I'm giving you the 2 minutes. That's the 2 minutes I'm talking about. Proceed.
Okay, yes. Thank you, Your Justice. As the learner's conduct infringed other learners' rights to basic education, the school had to send a message to ensure that the learners do not disrespect the Constitution and the school's code of conduct, section 4. Because according to the Anthony versus Governing Body Settlers High School 2002 case held at the Constitutional Courts, paragraph 17 states, the question should be asked is whether or not the prohibition is aimed at promoting positive discipline and whether or not non-compliance thereafter justifies punishment and also a form of censuration. This requires a spirit of mutual respect, reconciliation, and tolerance. Another case I would like to refer the court to is the case that was heard on this very same court, the Welcome High School case to 2014, paragraph 58, which states, a code must be aimed at establishing a disciplined and purposeful school environment catered to the maintenance of the quality and the learning process. Your Justice, on the state of facts, paragraph 1 to paragraph 3, was a quick summary on how Mjondolo High School was before the arrival of misconduct of Miss Koza and how it was after the arrival of Miss Koza. Since the school is an organization that is meant for teaching and learning, where all learners are supposed to.
We have 30 seconds, Council.
To be safe and to stick to other rules and policies. Any learner who deviates to what is stipulated in the school's code of conduct has to be disciplined. Your Justice, we submit that as the respondent, section 4 of the school's code of conduct was not infringed and it did not violate the learners' rights to basic education and their rights to privacy. We also submit that the SGB's decision did not violate the learners' rights to peaceful assembly. We would like the courts to rule in our favor. I think.
Thank you very much, Council. So we are out of time. I would just for future reference for both teams, right? Please also consider the principles of legality, right? So this is where you define the specific unlawful act, you prescribe a penalty, and that rule doesn't apply retrospectively. This is with specific regards to page 2, paragraph 5. I'm giving you gold here. So please just focus on that and think around that as well as what I've said to the previous team. I don't know whether the other justices have anything to say, just very shortly, before we can move on to the other court.
We can move on. I have nothing from my side. Thank you. Justice.
Okay, excellent. Justice Somo?
Nothing from my side. Thank you.
Thank you very much. I think we can all leave the room. Thank you very much.
Sorry, Justice, we didn't get
Yes.
our rebuttal.
You didn't request it.
We're requesting for the rebuttal.
You can't request it now. Your 20 minutes has been done. So remember at the beginning, I did inform you that you have 20 minutes to speak. If you decide to reserve rebuttal time, you can reserve that 3-minute rebuttal time. And then that means you'd have 17 minutes to speak. I even said while you guys were finishing off your arguments, as Justice Somo was asking you some questions, that there's only 5 minutes left. I know that you guys have not reserved any rebuttal time. So your total time that is left is 5 minutes. So going on into other courts, you have to expressly reserve your rebuttal time. So this would mean that you only have 17 minutes to speak between yourselves, and the respondent will then speak for 20 minutes, and then the 3 minutes will be added. Am I understood?
Yes.
Thank you very much.
I will be one of the judges today. I would just like the other judges to also introduce themselves to you.
Hi everyone, my name is Promise Traga. I'm also gonna be one of your judges today.
Hi, everyone. My name is Moanwa Ramanyini, and I'll also be a judge here today. Thank you.
Brilliant, thank you. Okay, so I think we shall start with the proceedings. Will the first speakers please introduce themselves?
Good morning, your justices. My name is Remo Amuhetsi Mwegezi, and I am counsel for the applicant. I would like to reserve 9 minutes for myself, and my co-counsel, Tapiwa Matumbura, I would like to reserve 8 minutes, and I would like to reserve a further 3 minutes for rebuttal.
Okay, granted.
If it pleases the court, I would like to make the first submission. The legal facts and the legal question. In the case before the court, the 6 learners, who will hereinafter be referred to as the applicants, asserted that Section 4 of the School Code of Conduct of Njondolo Combined School is unconstitutional and violates the applicant's rights to privacy, basic education in terms of Section 14, which is privacy, and Section 29, which is education of the Constitution of the Republic of South Africa at Article 8 of 1996. Furthermore, the school governing body's decision to suspend for the maximum period the applicants, Precious, who was 16 years old, Sabo, who was 17 years old, Apiwe, who was 16 years old, Eddie, who was 17 years old, and Crystal, who was 15 years old, and lastly, Mbali, who was 14 years old, was in extremis and a gross overreaction to the applicant's right to privacy, Section 14, and rights to expression, Section 16, and to peaceful assembly in terms of Section 17 of the Constitution. As counsel for the applicants, we submit that the relevant sections were a direct infringement on the applicant's rights and that their constitutional rights were unjustly limited. If it pleases the court, I would like to make my second submission. There is a quote by Martin Luther King Jr., which states that never forget that everything Hitler did in Germany was legal. Now, what the applicant would like to submit to the court is that the restriction on the well-being of the learners defeats the purpose of the effective learning process. And the applicant describes the effective learning process as agreed upon along with the respondent as well, discipline that is necessary within the school, and improvement in the capability or ability of the learners. Now, moving further, making a further submission, the regulation on the use of cell phones. Now, the applicant would like to submit that learners need phones so that they can make full use of the learning process. The demographics of Braamfontein indicate that it is difficult for learners to actually work to do their schoolwork, keep up with their homework, due to parents working long hours. Some kids arrive home late, others have to do all the house duties while their parents are at work. Where else can they make the most of their education? The only place they can do this at is at school, and through the use of cell phones, through the help of cell phones. Furthermore, learners need cell phones in order for them to arrange transport so that the high crime rates on the streets of Braamfontein don't end up catching them as well, wherein we understand how many people are the possibility of getting kidnapped and things like that. And so the applicant therefore submits to the court that it is necessary for the applicant to have cell phones in the classroom in order for them to be able their own safety, and furthermore to be able to work well in class and use their education effectively. Now, the Constitution protects the students in the case here with Section 16 B and D. Section 16B and D, if the court will bear with me, please. Right, Section 16B being freedom to receive or impart ideas, and Section 16D, the academic freedom and scientific research. Now, the respondent alleges that its limitation of the learner's rights was justifiable on the grounds that it was instilling much needed discipline in a school with very little in the way of structure and method of dealing with the behavior of the learners and the conduct of the teachers with absenteeism and all that. However, what the applicant would like to submit is that there were less restrictive means than the heavy-handed approach that the respondent took through the Section 4 Code of Conduct, which stated, and I quote, "The use of cell phones, whether on or off, by learners on school premises shall at all times be prohibited. Any learner that is found in possession of a cell phone shall have that phone confiscated and may be suspended." The applicant would like to submit that there were less restrictive means that could have been used to achieve the purpose to instill discipline. The means that the applicant would like to submit to the court is that the respondent could have created or formed a structured code of conduct which provides provision for varying degrees of severity with which the code of conduct can be breached. This could have been done through a point system that has different levels, that shows different levels of transgressions. Not only would this achieve the discipline needed, it would provide much needed leniency towards cell phone use in order to accommodate students. To cite a case in which the court granted—
Counsel, I would like to refer you back to your reference to Section 16 of the Constitution. You referenced academic freedom. How does that tie to learners' access to cell phone use?
My Justice, the applicant would like to submit that academic freedom ties into the student's cell phone use in the sense that learners can use cell phones in order to use the internet to do research required for projects, to do research required to help them with homework through various media such as YouTube, helping them where they wouldn't have understood in class, providing them further time in order to understand what they learned in class, seeing that they might not be able to do it at home. And therefore—
Is there no internet facilities via computers available on the school grounds?
My Justice, the applicant would like to refer the court back to the demographics of the school in Braamfontein. So we're talking about a school that doesn't have much in the way of structure, that already has a terrible reputation in terms of the high absenteeism between the teachers and students, and therefore from the lack of the set of facts given within the school, the applicant would like to refer the court to the demographics of the area, which indicate that this is not a school which is very well resourced. And
thank you, counsel. Thank you. You can resume your argument.
Thank you, Your Justice. Yes, the applicant would like to submit as before that not only would have a point system with different levels of transgression would have achieved the discipline needed, it would have also provided much needed leniency towards cell phone use to accommodate students. However, the heavy-handed approach taken by the school didn't instill discipline, it instilled fear. And should the fear in the learners break, chaos is bound to ensue. And considering that the case has events have led to an actual court case, it is quite fair to say that the fear in the learners did break. And because there was no discipline that was achieved, only chaos ensued. The applicant would like to further submit that the child's best interest here is to empower, is all that empowers and equips learners to well-rounded individuals. The fear dynamic being instilled doesn't achieve this purpose. Instead, the negative effect that it has on the self-esteem of the learners and on the self-worth of the learners only negatively affects them emotionally and mentally. And thus it is not in the child's best interest. If it pleases the court, the applicant would like to move on to its second submission. Privacy. Now, the applicant would like to submit would like to refer the court to a case. The applicant would like to submit the court to a case where Justice Ackerman in the Bernstein versus Bester case extensively discussed that unless there are certain actions within the personal sphere or certain positions within the personal sphere of learners which extend negatively to communal relations and activities such as business and social interaction, which in the case lying before the court today, communal relations would be the learning environment or school itself, the privacy of an individual cannot be invaded. Now, the code of conduct, the Section 4 code of conduct implemented by the school states that the use of cell phones, whether on or off by learners on school premises, shall at all times be prohibited. What the applicant would like to submit to the court, that cell phones when off, cannot in any way, cannot in any way disrupt the learning process. And therefore, the school is not protected in any way and is not justifiably limiting the learner's rights to privacy when invading their personal sphere to take away their cell phones. And therefore, the applicant would like to submit that the respondent's limitation of the students' rights in the terms of privacy was unjustified. Now, if it pleases the court, I would like to take my leave and refer to my co-counsel and allow my co-counsel to take the podium. Thank you.
Good morning, may it please the court. I appear on behalf of the applicant in this case. If it pleases the court, I'd like to go to my first submission. The applicant's right to be heard. In the case upon the court, the applicant submits that the applicant's rights to be heard were indeed violated. And as such, I refer the court to Section 33, just administrative action of the Constitution. To quote this, everyone has a right to administrative action that is lawful and reasonable and procedurally fair. Administrative action. The applicant would like to submit how administrative action is defined as any action taken or any failure to take a decision by subsection A. When referring to an organ of state, it is exercising power in terms of the Constitution, or exercising public power or performing a public function in terms of any legislation. Everyone, as stated by the right, everyone whose rights were adversely affected has the right to be heard, of which the learners felt their rights were not heard. This imposes the question: is there an RCL council present? Your justice, it is not clearly stated in the state of facts given if there was RCL council. But from the outburst and major issues that the learners had with the passing of the code of conduct, we can deduce that either there was no presence of the RCL But according to chapter 2, section 11 of the SA Schools Act, which states that a representative council of learners at the school must be established at every public school enrolling learners in the 8th grade of high or higher, we then deduce that if there was the RCL council, it indeed was not functional and thus did not voice the students' concerns. As such, we believe that the students' rights to just administrative actions were not properly delivered to them. As such, I would like to refer the court to chapter 2, section 8 of the SA Schools Act, which is the Code of Conduct. It here states in this act, subsection 1, that subject to any applicable provincial law, a governing body of a public school must adopt a code of conduct for the learners after consulting with the learners, parents, and educators. This can be called the triumvirate in passing a code of conduct. And as per the set of facts given, it is not clear if the learners were consulted, as they form part of the triumvirate needed for the passing of a code of conduct. Therefore, we can say that section 4 of the school code of conduct of Mjondolo Combined High School was not justifiably passed. As such, the applicant submits that the respondent did not keep to section 3 of the Constitution and violated the applicant's rights to be heard, as well as section 4 of the Code of Conduct of Mjondolo High School is unconstitutional. The applicant has no further submissions on this point. So unless the court wishes to address anything or to be addressed on anything, the applicant can move on to a further submission. To move on to my second submission, the consultation as a restorative process, quoting Ubuntu. The school acknowledged that there might be underlying social issues within the school and called for a meeting with parents. Your Justice, I'd like the court to know how there was no mention of learners being involved in this process. The learners, in fact, protested at the school the night of such meeting and expressed their dissatisfaction with the harsh suspensions. The core of Ubuntu is that a person is a person through the interactions with others. The school's lack of consideration showed the disregard of the applicant's rights and Ubuntu should be the root of human rights issues. If it pleases the court,
Council, is Ubuntu formally part of the constitutional dispensation of South Africa?
Your Justice, Ubuntu is a founding value in South Africa. It is a value that was majorly expressed upon by the former president, Nelson Mandela. So, Your Justice, in a matter that concerns the child's best interest, we should in turn include humanity, which is Ubuntu. If it answers Your Justice's question, I'd like to go on to my third submission.
Council, I accept your reference to Nelson Mandela, but that is not a source of legal authority. Is there any case that you can refer me to that recognizes Ubuntu as a fundamental principle of justice in South Africa?
Your Justice, in my second submission, I speak about the restorative process. I express how the learners were not included in this process. I state Ubuntu. I only emphasize upon Ubuntu, Your Justice, as it is a core value in the morals of South African citizens. Your Justice, this is not me stating that Ubuntu is the core of the Constitution. Does that answer Your Justice's question?
Thank you, Council. You can move on.
To move on to my third submission, Your Justice, the limitation of rights, as per Section 33 of the Constitution. I would like to start by quoting subsection 1 of the Constitution. The right in the Bill of Rights may be limited only in terms of the law of general application and to the extent that the limitation is reasonable justifiable in an open democratic society based on human dignity, equality, freedom, taking into account all the relevant factors. A being the nature of the right. In the case presented upon the court, the nature of the right in this case is to ensure that the learner comply with the school code of conduct, to create and preserve an adequate, safe, and improved in education and learning environment. To go on to be the importance of the purpose of the limitation. The purpose of the limitation is to ensure a disciplined and healthy school environment. C, Your Justice, the nature of the extent of the limitation. In this case before the court, Your Justice, the applicants have made that the nature of the limitation is extensive and harsh, and the extent of the general possession of cell phones, not the use of cell phones itself on school premises. D, Your Justice, the relation between limitation and its purpose. The relation between the limitation and its purpose is to achieve a high standard of learning. Was blown out of proportion, as the limitation only served to inspire unsettlement, distrust, and intensified dismay in the school, in turn achieving the opposite purpose. E, less restrictive means to achieve the purpose. As emphasized by my co-counsel, the word countless less restrictive means to achieve the same purpose. There is less restrictive means to achieve the same purpose, such as a demerit merit system, hearings and confiscations of cell phones if found in use on school premises. In turn, limiting the use of cell phones on school grounds rather than the possession of cell phones themselves. As my co-counsel stated, the code of conduct could have been structured in a way which provides varying degrees of severity with which the code of conduct can be breached. As per subsection 2,
thank you, counsel. As I understand, your time limit has been reached.
If it pleases the court, I would like to do my prayer of release before taking my leave.
All right, you can go ahead.
We pray that the Honorable Court issues an order in the following terms. A, that Section 4 of the School Code of Conduct be declared unconstitutional and that it violates the learner's rights to privacy, basic education in terms of Section 14 and 29 of the Constitution. B, that the school governing body's decision is unconstitutional and violates the learner's rights to peaceful assembly in Section 17 of the Constitution. C, that the independent investigation be launched on the use of corporal punishment at the school. D, that the cost of suit, and E, further and/or alternative reliefs.
Thank you, counsel.
Justice Olivier, sorry if I'm not pronouncing your name right. Can I just ask a question, please?
Yes, of course.
I just wanted to ask the counsel for the applicants, do you think, I know in your prayers you said you want the section 4 to be declared unconstitutional, but can you please tell me if you think the section in its entirety is unconstitutional, or if only parts of it is unconstitutional? And if it's only parts of it, how would you amend it to make it in line with the Constitution?
If it pleases the court, I would like to confer with my co-counsel. If it pleases the court, the counsel for the applicant does submit that per section 14 14A, B, and C were directly infringed, as well as Section D, which will be inferred upon the rebuttal done by my co-counsel. If it pleases the court, I'll take my leave.
Thank you.
All right, if there are any other questions from the bench for the applicant?
Not from my side, Justice.
Okay, thank you.
Not from my side as well.
Thanks. All right, now we shall move on to the submissions of the respondents.
As the court pleases, I am Aluto Luata, and I will be appearing on behalf of the respondent. My co-counsel, Ms. Mutzikani, will be addressing issue 2, whilst I address issue 1. I have allocated 10 minutes of my argument, leaving my co-counsel with another 10 minutes of issue 2. Now, your justices, the applicants made the following errors in their argument. Firstly, we submit that the frequency of transport in Brumsontain is absolutely adequate, your justices. Therefore, the applicant cannot state that they needed cell phones for transport, as there's a great amount of availability of transport in Brumsontain, your justices. Now, your justices, according to page 2, paragraph 1 of the state of fact, it clearly states that there was a consultative process. Now, furthermore, your justices, we submit that we refer to section 24 of the South African Schools Act that clearly states that an SGB is already confined of and made up of the representative council of learners. So Njondolo Combined School did have a representative council of learners. Now, your justices, the counsel for the respondent stands by its firm decisions of suspending the learners and the applicant for defying section 4 of the school's code of conduct. Reason being that we refer to paragraph 58 of Head of Department, Department of Education, Free State Province versus Welcome High School, and another, Head of Department, Department of Education, Free State Province versus Harmony High School, and another of 2014 that was ordered by the Constitutional Court that states that a code of conduct must be aimed at establishing a disciplined and purposeful school environment that is dedicated to the improvement and maintenance of the quality of the learning process. Now, your justices, section 8, subsection 4 of the Schools Act continues to state that nothing contained in this act exempts a learner from the obligation to comply with the code of conduct of that school attended by such a learner. Now, your justices, we put into great aspects the importance of abiding to a code of conduct. Reason being that, your justices, a code of conduct is not implemented so that the learners can defy that code of conduct. Now, the counsel for the respondent, in line with the Schools Act, the Constitution, as well as paragraphs, will demonstrate that section 4 of the Schools of Code of Conduct is indeed unconstitutional. It does not violate the learner's right to privacy and basic education in terms of section 14 and 29 of the Constitution. Permission to begin on issue 1, if it pleases the court.
Counsel, before you continue, I would just like to ask about the possibility of lenience in the code of conduct. You stated that the school of conduct code cannot be violated. Is there any circumstances wherein which different measures will be explored for punishing the students if circumstances so require?
Yes, your justices, the section 4 of the Code of Conduct does state that the learners may be suspended, implying that if reason if they make representation to their suspension, they would not be suspended, Your Justices.
All right, Counsel, you may continue.
As derived from this case, the respondent would like to bring it to the court's attention that many of the learners and educators of Umjondolo Combined School agreed with the need for greater discipline, even before the implementing of the new Section 4 of the Code of Conduct. Now, this goes to show that it wasn't the school alone that made a decision for improvement in the school, but rather we submit that all the members of the school came together democratically and pleaded for change. With this being said, we submit that the respondent met its requirements of involving the parents, the learners, and educators of that school as required in the guidelines of implementing a code of conduct that was recognized and amended by the Department of Education. This would then highlight 5 submissions, Your Justices. Now, Your Justices, Umjondolo Combined School is a public school. And according to Section 15, Subsection 1 of the Schools Act, every public school is a juristic person with the legal capacity to perform its functions. Second, we submit that the need for greater discipline that was called upon by all the learners and educators had to be adhered to by the SGB. As the functions of all the governing bodies of the school, according to Section 20, Subsection 1A of the Schools Act, are to promote the best interest of the school and strive to ensure its development through the provision of quality education for all learners of that school. Quality education had already been compromised by the use of cell phones in the school. Third, we submit to this honorable court that the governing body of the school is indeed responsible for adopting a code of conduct for the learners at that school, according to Section 20 of the Schools Act. Third, we say that the governing body of this school is rather obedient in that it meets its people's needs and it also fulfills its responsibility and stands in positions of trust in accordance to Section 20 of the Schools Act. Lastly, we respectfully suggest, Your Justices, that it would be more lawful that if need be, if the court finds the respondent guilty of an offense, the court would also find the rest of the learners and educators of that school that pushed for greater discipline all guilty of an offense, Your Justices. Now, the counsel for the respondent denies its charges of infringing on the applicant's rights to basic education in terms of Section 29 of the Constitution. Your Justices, the court cannot be oblivious to the reasons why Section 4 of the Code of Conduct was amended and implemented in the first place. As Section 8 of the Schools Act emphasizes that the Code of Conduct of a school must be aimed at establishing effective education. Now, if you could recall to the state of facts, Your Justices, learners of Umjondolo Combined School use their cell phones in class, and they were on social medias. And the teachers of the school found it difficult to teach under these circumstances. Therefore, we state that effective education was not maximized, Your Justices, as the teachers could not teach under these circumstances. And thereafter, a code of conduct had to be implemented. On that matter, the counsel for the respondent submits that they rather embraced education. They allowed for education to take place in its maximized proportion in the school, Your Justices. The mere fact that this code of conduct was implemented in the first place is evident enough, Your Justices, that the respondent adheres to Section 8 of the Schools Act. That stipulates
Counsel, was there less restrictive means by which order in a classroom could have been established other than the measures taken by the school?
No, Your Justices, there wouldn't have been any less restrictive measures because if you remember, Your Justices, in accordance to the state of facts, Cell phones had caused great distraction in the school, being that the pass rate was absolutely very low, Your Justices. And the process of the Code of Conduct was to mitigate such repercussions, Your Justices, to maximize effective education.
So it was not possible, for example, to simply outlaw the use of cell phones while class was in session, and instead of outlawing the use of cell phones altogether during school hours?
Yes, Your Justices, because there were many methods that the school have in presentation to the fact that it's a school. They could have internet access as a school. They could use the laptops and of the school. There is no need for cell phones in the school, Your Justices. Therefore, they should not be brought at school in the first place, Your Justices.
What about the applicant's submission that there was not a sufficient amount of resources available on school premises for the students to have efficient access to the internet?
Your Justices, the state of facts does not help and align to what they have stated, Your Justices. If a school accepts the amount of learners that it accepts, it is willing to have the responsibility to adhere to everything that every learner of that school requires, Your Justices.
All right, Council, you may proceed.
Your Justices, on that matter, the counsel for the respondent state that the distraction that was caused by cell phones in the school was also unacceptable. If the respondent did not implement a new code of conduct, it would then suggest that the respondent cares less about education and then would be limiting the learner's rights to basic education, according to Section 36, Subsection 1 of the Constitution. The right to an education, according to the Bill of Responsibilities that was recognized by the Department of Education, places a responsibility on the applicants, the 6 learners, to adhere to rules and the code of conduct of the school. Therefore, the respondent confirms that the right to privacy in Section 14 was now also not infringed upon. The South African Schools Act, in accordance to Section 8, Subsection 3A, states that a search must be conducted after taking account all relevant factors, such as relevant evidence and the best interest of that school and the learners alike. Now, the best interest of the school would be maximizing effective education that had already been compromised in Umjondolo Combined School, and creating a comfortable environment for teachers to teach, and the learners that did not even bring cell phones in the first place to also learn, Your Justices. Now, the relevant evidence in this case being that a few days right after Section 4 of the School's Code of Conduct was implemented, Special Tele's phone falls out of his pocket. Now, Your Justices, we submit that this is evident enough that a search had to take place, being that the respondent had to make sure that the rest of the learners of Umjondolo Combined School are not just like Special Tele and are actually adhering to Section 4 of the school's Code of Conduct. And Your Justices, displeasingly, the applicants were found with cell phones in that school, meaning that they were defying Section 4 of the school's Code of Conduct. The principal of a school, according to the definitions of the Schools Act, is an educator that stands as the head of the school. Thereby, we submit, Your Justices, that it would have been rather incompetent of Ms. Koza to be ignorant to the situation at hand, being that the applicants were defying Section 4 of the Code of Conduct. Not only is she the head of the school, Your Justices, but Section 16A, Subsection 2D of the Schools Act states that provides the principal with the responsibility to assist the governing body to handle disciplinary matters that are pertinent to the learners. A random search need not to be notifying anyone, Your Justices, as it is written as a random search according to the South African Schools Act. Random meaning unarranged. But the respondent put out a notice as a measure of mitigating such repercussions, We submit this, Your Justices, that the respondent handled the search rather leniently. Reason being that this search was not aimed at infringing on anyone's right, but rather to maintain order and discipline that had been lost for so many years in Mjondolo Combined School. I would like to contextualize the case as I reach my conclusion. Your Justices, as a notice was sent the day before the search, you would expect that the applicant would leave their cell phones, at least for the day of the search, to say the least. Now, this rebellious resistance alone, Your Justices, has proven to us that the applicant does not respect the respondent. They appear unafraid and unbothered that their cell phones could be confiscated and that they could be suspended. The respondent doesn't even need their cell phones at school for effective education if they're also willing to have that phone confiscated. Now, Your Justices, bringing a cell phone to school on the day you have been warned that there will be suspension confiscation is seen as willingness to have that phone confiscated. Thereby, the counsel for the respondent submits that this is evidence that cell phones are of no good use in the school premises, and thereby that is how the applicant was willing to have them confiscated. It is for those affirmative reasons that we plead with this honorable court to testify and declare that the High Court was never inaccurate for ruling in favor of the SGB, as it only sets out decisions to assist the school in ensuring that there is effective education and learning. Now, the respondent also pleads with the court to order that Section 4 of the Code of Conduct is constitutional. It would also be well appreciated that the court rules in favor of the suspension so that these learners will learn from their misconduct. In light of the facts and substantiating laws brought forward, the respondent would like to take permission to take leave if it pleases the court, leaving my co-counsel on the stand to discuss the second issue.
Thank you, counsel. Your co-counsel may proceed.
Can I just ask a question at this stage?
Yes,
of course.
Do you think, I see there's a word may suspend the learner in the Code of Conduct, right? But it appears that the principal or the school just suspended all the learners, even though, can I call them, the transgressions were not really the same in a way. They all had phones, but some of them were switched off, and whatever the circumstances are, they didn't really give the learners the opportunity to be heard or to maybe even provide a reason why. Maybe there was an emergency at home that they need, like whatever the reason might be. But do you think procedurally, assuming that the section is constitutional, but do you think that the process that was taken was correct, or do you think that there needs to be more guidelines, and what would be what would the guidelines be if you think there should be more guidelines?
Your Justices, thank you very much for your question, but I would like to refer to you to the fact that, yes, Your Justices, the respondent found that it was unlawful in the fact that it didn't give the rest of the learners a chance to a disciplinary hearing. However, in the state of facts, it refers to the fact that a meeting was called upon by Ms. Koza. She specifically stated that if mistakes have been made, that they would come together as a school and discuss a way forward. Now, Your Justices, this meeting couldn't even take place because the applicant took it upon themselves to stop the meeting from taking place. Therefore, fixing of the errors that were made, Your Justices, could not take place. And that is not in the fault of the respondent, but rather the applicant, being the 6 learners, Your Justices.
Then, counsel, do you agree that the section needs a bit of guidelines, as the school might have accepted that there were some errors that were made? Just maybe like limitations or a process to be followed or something like that?
Of course, Your Justices, it does need to. And that is exactly why the school took it upon themselves to fix their errors. It is not that they were oblivious to their errors, but they also found that they were inaccurate in what they had done. As a school, for Your Justices, they played a role for rather fixing their errors. So they do themselves know that there was errors that were taken and they were mistakes, and therefore they're willing to have a way forward.
Thank you, counsel.
Thank you, Your Justices. If it pleases the court.
Your co-counsel may proceed.
As it pleases the court, with my 10 minutes, I will be arguing that the SGB's decision is not unconstitutional and does not violate the learner's right to peaceful assembly in terms of Section 17 of the Constitution. The counsel for the respondents making use of the Constitution, the South African Schools Act, and articles will prove that the applicant's allegations of the SGB's decision being unconstitutional and violating their right to peaceful assembly are however false, and that the courts are not inaccurate in ruling in favor of the SGB. Drawing back to the state of facts, we are assertive that on the day of the search, obedient learners kept their phones at home and were compliant with the code of conduct. Therefore, it will be unjust to those obedient learners if the SGB overlooked the misconduct of the 6 learners. My co-counsel has already dealt extensively on the issue regarding the SGB and the code of conduct. However, for the sake of my argument, an SGB comprises of learners, parents, and teachers of the school. This inevitably proves that the learners were fully on board with everything stipulated in the code of conduct. Now, your justices, we are aware that not every learner was thrilled with the implementation of this code of conduct. However, we do submit that if the learners were displeased with the punishment, they should have taken the right manner of approach, which is petitioning their grievances to the RCL bodies and them coming to us, and therefore we can reach a consensus with the learners, of which that did not happen. The principal calls for a meeting, which was to be held at 6 o'clock. Unfortunately, that meeting does not take place as the learners had barricaded the entrance. Your justices, the South African Schools Act states that the problems and issues of the school should be resolved at school. We can boldly allege that the applicants defied this ruling as they took a more publicized approach. Instead of attending the meeting and actually petitioning their grievances to the school, they rather stood outside and create a scene. Section 16, subsection 2A of the Constitution attest to spreading false information for war. The applicant was very assertive that it's cause of causa, to which it's false because it's cause of the learners' rebelliousness and resistance against a simple ruling, which was for their betterment. The applicants infringed upon their fellow schoolmates' rights to basic education. This is because teaching and learning could not take place. Learners had to take a U-turn by the gate. The applicants also violated road users as well as the SGB's right to movement as they could not gain access to the school or the roads. Your justices, paragraph 43 of the Mungwane and others of 2019 states that everyone has the right to picket, everyone has the right to assemble, demonstrate, picket, and present petitions. The only internal qualifier is that anyone exercising this right must do so peacefully and unarmed, to which there was no peace as there were trash cans on the roads, there was destruction of schooling and learning. This is further justified with the South African Schools Act of 1996, number 84, which states that when the expression leads to material and substantial disruption of school operations, activities, or the rights of others, the right can be limited. Simply put, the right of the learner's expression can be limited because they infringed on other people's rights included. Your justices, we cannot look away from the fact that they were resistant to the law given to the warning given to them by the police. On the first day of the strike, their excuse was it was a spontaneous strike. However, the state of fact states that the learners went home and prepared for another strike. In that instance, you'd expect them to also prepare a notice. Your justices, the respondent's decision is further justified by the Schools Act of 1996, number 84, stating that any corrective measure or disciplinary action must be commensurate with the offense and infraction. Corrective measure may become more severe with subsequent repeated infractions. Learners should not think that they cannot be suspended because it's their first offense. This is because the first time that they were presenting their petition, their excuse was it was spontaneous, of which the police told them to evacuate because it had no notice. They went home prepared for another protest and still do not have a notice. This is rebelliousness and resistance to law. Your Justices, I present before you Section 11, Subsection K of the Schools Act of 1996, number 84, stating that repeated violation offenses of the school rules and code of conduct can lead to suspension. The counsel for the respondent submits the accusations made by the applicants regarding the infringement of the right to peaceful assembly being false, because your Justices, looking at the state of fact, in all the circumstances or in all the instances of the rioting, it was the police who were immobilizing this protest and not the school. Therefore, we are not liable to that to the immobilization of those strikes. To further substantiate further, we found that Precious was arrested not by the respondent, however, by the school. Section 3 of the Gatherings Act states that the convener of a gathering shall give a written notice for the intended gathering. Your Justices, the respondent did not receive any gathering. Therefore, how do we violate their right to peaceful assembly if they never came to ask for it in the first place? Your Justices, as I reach my conclusion, paragraph 16 of the Mnungwana and others of 2019 by the Constitution states that if a gathering proceeds without a formal notice, then Section 12(1)(a) provides that it is a criminal offense to the convener. Now, your Justices, it is a criminal offense because why then would the police get involved? If truly a spontaneous strike is recognized by law, then the police would have left the learners to proceed. However, they quickly immobilized it because a spontaneous strike is not recognized in the eyes of the law, and notice needs to be given. In conclusion, your Justices, it is for this affirmative reasons that we plead with this honorable court to pledge that the courts of call were not inaccurate in ruling in favor of the SGP, as their decision is not unconstitutional and we did not violate the learners' rights to peaceful assembly in terms of Section 17 of the Constitution, and that Section 4 of the Code of Conduct is, however, constitutional, and that the suspension should, however, be kept. If it pleases the court, I may take my leave.
Thank you, Counsel. Are there any questions from the bench about the respondent submissions?
Not from my side, Justice. Thank you.
Not from my side as well.
Thank you very much. Time was reserved for rebuttal. If the applicants would please proceed with their rebuttal.
Good morning, once again, my Justices, your Justices. I would like to begin with my rebuttals. Now, the first rebuttal the applicant would like to submit to the court is on the issue of gatherings and the demonstration by the students. Now, firstly, what the applicant would like to submit to your Justices is that the first gathering, which was started by the applicants after their bags were searched and phones were found, they were suspended. That gathering was a spontaneous gathering, and as protected in the Constitution, everyone has a right peacefully and unarmed to assemble, demonstrate, picket, and to present petitions. The applicant would like to submit that gathering was spontaneous and did not need any notice to be given. And furthermore, the applicant would like to submit that the 10 learners who then joined the spontaneous gathering by 6 after it had taken place. Those 10 learners joined of their own accord. The 6 never planned it. And so even though the 10 learners, even though the 10 learners joining into the gathering began violating the Constitution, these learners cannot be held liable because they never planned that. Secondly, The second gathering which took place, when the principal wanted to convene a meeting between herself and the parents, the applicants that went out to actually make this gathering was to make this demonstration actually was Eddie, Crystal, and Buddy. It was only them. It was only these applicants, the 40 learners who ended up joining the process, again, joined of their own accord and out of their own frustration, because the news, and I'd like to quote from the identical case given, the news of arrest and detention of the learners had reached the broader group of learners. And therefore, what the applicant would like to submit is that, once again, the applicant cannot be held liable for the 40 learners who ended up joining in the protest, because they never planned for the 40 learners to join in their protest. That was out of their frustration. Now, with the final submission that the applicant would like to submit to the court is, once again, to quote Martin Luther King: "Never forget everything that Hitler did in Germany was legal." Why? Why was it so bad if it was legal? Because it lacked humanity and it lacked equality. Now, the applicant would like to submit to your justices that to Section 39 within the Constitution, when interpreting the Bill of Rights, a court, tribunal, or a forum must promote the values that underlie an open and democratic society based on human dignity, equality, and freedom. Why? So that even though the actions might be legal, just as they were under Hitler's reign, they're not as inhumane as they were when it comes to the Holocaust. The final submission, the one last submission that the applicant would like to submit to the court refers once again back to the issue of transport, refers back to the issue of suspensions. By that, the applicant would like to submit to the court is that the suspensions used as a means, to implement the code of conduct within the school are arbitrary on the basis that they have no structure. Some learners get suspended for 6 months, which violates the SA Schools Act, in which a learner can only be suspended for no longer than 1 week. And therefore, the applicant would like to further submit that with no order within the suspensions and with the code of conduct having absolutely no provision whatsoever, these decisions, the suspension and the code of conduct itself the respondent was arbitrary in its application and its instilling of the code of conduct. The last submission that the applicant would like to submit to the court is on the basis of transport. Now, taxis. There is an abundance of transport in Braamfontein, indeed. Taxis, right? Learners go to school with taxis. They use their cell phones in taxis. And with the essays and with the Section 4 code of conduct within implemented by the school is now imposing itself outside, is now extending its code of conduct outside its sphere of authority, and is actually leaning into the learners' personal lives, where now it's extending outside the school, and their cell phone use is now being infringed on outside the school. Secondly, Taxify can be used. The learners need cell phones in order to be able to use Taxify, in order for them to be able to get the transport that they need to go back home. Lastly, the applicant would like to make a final submission on the basis of Ubuntu. Now, once again, referring back to our constitutional values, which are founded on humanity and empathy, to avoid any inhumane processes as legal as they might be enshrouded as. Now, as I've already referred the court to Section 39 of the Constitution, I'd like to refer it back to Section 1 of the Constitution, wherein the Republic of South Africa is one sovereign democratic state founded on the following values: human dignity, the achievement of equality, and the advancement of human rights and freedoms. The exclusion of the learners in the process, taken in order to create a comfort zone for teachers. A comfort zone for teachers cannot happen at learners' expense. Secondly, learners being excluded from a meeting wherein the principal admits that things are not going okay. The learners have been shouting that they feel that their rights are being infringed on, and the principal hasn't taken any leave to actually listen to them. And once again, she excluded them from the meeting, wherein it's supposed to be a triumvirate between the learners, between the students, and between the learners, between the teachers, and between the parents. And if it please the court, the final submission I'd like to make before I take my leave is that the respondent has lacked empathy in how it has dealt with the learners. It has lacked humanity in how it has dealt with the learners' concerns, and has referred to the learners voicing their concerns about their rights being infringed as disrespectful. Once again, I'd like to refer back to the nickname general, which was given to the principal. There's nothing more which indicates the force with which the principal implements her code of conduct within the school. There's nothing more, there's nothing better to indicate how she lacks complete humanity, her actions lack complete humanity, lack total empathy, and not in any way, and are not in any way in the child's best interest, but also to fulfill the mandate. If it pleases the court, I would like to take my leave. Thank you.
Thank you very much, Council. I now will create opportunity for my fellow justices to ask questions if they wish to.
I don't have any questions, but I would just like the names of the council for both teams because we didn't get that in the beginning. Maybe the applicant's council can start and give us their names.
Your Justice, my name is Nsmcc, and my co-counsel.
Sorry, can you spell for us, please?
It's RBM.
Maybe just the surname. You can spell just the surname.
L-E-K.
Sorry?
O-E-K.
O-U-K.
O-E-K.
Oh, O-E-K, okay.
E-T-S-I.
E-T-S-I. Or is it Moeketi?
Yes, it's Moeketi.
Oh,
yes.
Okay, all right. The other one?
Your Justice, I am Tapiwa Nation Matumbura.
Can you spell your surname?
M-A-T.
Yes.
U-M-B. U-R-A. U-R-A.
U-R-A. Tumbura. Okay, thank you. And for the respondents?
Your Justices, my name is Alutho Luwaca. L-U-W-A-C-A. Luwaca.
W-A-T-S-A.
L-U-W-A-C-A.
C-A. Okay. All right. Thank you.
My co-counsel is Bertha Mutsikani. M-U.
M-U.
T.
Yes.
S-A-K-A-N-I. Mutsakani.
Mutsakani. Thank you.
Thank you.
Nothing further from my side. Justice Olivia.
Thank you very much. I will refer all the feedback that I have to in the score sheets. Or I would like to mention for both parties the importance of S versus Makonyane. As I understand, you both write arguments for the applicants as well as the respondents, and reference to Ubuntu. When that is made, please look at S versus Makonyane. I think that will just improve the quality of your arguments in reference to Ubuntu. I believe this is the end of the session, and I will now hand over to the next Chief Justice. Everybody who is not supposed to be here for the next session, please leave.
you please confirm each of your speakers what your names are, name and surname, and tell me how many minutes you'll be speaking for each, please, and then I'll do the same with the respondent afterwards. So first, the applicant.
As it is the court, I'm Councillor Telezani Itmile. To my right is my co-councillor Disebo Mtandazo. We will be representing the applicants, my justices, and I will use 10 minutes of the court's time. My co-councillor will use 8 minutes, and the remaining 2 minutes will be left for the rebuttals, my justices.
Thank you for that. If I could just ask you to spell out each of your names for me, I just want to make sure that I have it correctly.
Itumeleng, Telezani Itumeleng, T-H-E-L-E-T-S-A-N-E. Itumeleng, I-T-U-M-E-L-E-N-G.
Diseko, D-I-S-E-K-O. Mtandazo, N-O-M-T-H-A-N-D-A-Z-O.
Okay, thank you very much to the applicant. If I could please ask the respondents to do the same. So just your name, surname, and how long you'll be speaking for.
As the court pleases, my name is Nsmcc and I'm with my co-councillor Untitled Chapter. We have allocated ourselves with 20 minutes, 12 minutes for myself and the remaining 8 minutes for my co-councillor. Mukwati, it's M-Q-W-A-T-H-I. Palisa, P-A-L-E-S-A. Thank you, Your Majesty.
To the Honorable Court, my name spells Unati, U-N-A-T-H-I. And my surname Chobeka, T-Y-O-B-E-K-A. Thank you.
Okay, perfect. Thank you to each of you. I just want to make the respondents aware that you are afforded the opportunity of sir rebuttal. So sir rebuttal is simply a reply to the rebuttal that applicant may make. You have the 2 minutes for your sir rebuttal. Okay, so we are going to proceed without the other judge. They will be joining us shortly. So like I said before, welcome everybody. My name is Judge Pillay, and I'm joined by my co-judges. And so to begin with the proceedings swiftly, I'd just like to make sure that everybody keeps muted except for those who are speaking. And we then call upon the first speaker of the applicant to present their pleadings before this court.
The question before the court is whether the High Court was correct not to hold Section 4 of the Respondent's Code of Conduct to be unconstitutional, and whether my clients, which I shall in great detail elaborate, was violated. We as the counsel for the applicants submit to this honorable court that the Respondent's Code of Conduct violated on my clients' constitutional rights to privacy of Section 4, basic education of Section 29, and peaceful assembly of Section 17, as I submit to the court. My justices, I would like to start my argument by firstly addressing the unconstitutionality of the Respondent's Code of Conduct. The Code of Conduct was firstly adopted because the school had a reputation of ill-manneredness and performing below the government's expectation. So the HCB saw the need to adopt a new code of conduct to enforce discipline, order, and to improve the school's reputation. But unfortunately, my justices, the code of conduct is detrimental to my client's rights. As Section 4 of the Code of Conduct reads, and I quote, "The use of cell phone, whether on or off, by any learner on school premises shall at all times be prohibited. Any learner that is found in possession of a cell phone shall have that phone confiscated and may be suspended." Close quote. My justices, this clearly means if a cell phone is found in possession of my client, or if my client is found in possession of a cell phone, that phone will be confiscated from them. The phone will be taken away from them. The phone will be seized away from my client. But my justices, Section 14 of the Constitution clearly states, and I quote, "Everyone has the right to privacy, including the right to not have their property seized and the right to not have the property seized, the possessions seized," close quote. My justices, this clearly means my clients have the constitutional rights not to have their properties seized, not to have their properties taken away from them, not to have their properties confiscated. It is clear that the governing body had more interest in enforcing discipline and improving the school's reputation than protecting my client's rights. And my justices, in the case of MEC, yes, my justice.
Before you tell me about that case, I would just like to know from you, while I understand the importance of the right to privacy, are there any circumstances where it's allowed to be limited so that the school can take some kind of measure to make sure that the children aren't on their phones and aren't distracted from their schoolwork?
Yes, my justices, there is. And South African Schools Act gives us clear guidelines on how to limit that right. As it says, as South African Schools Act says, the principal or his or her delegate may at random search any group of learners or the property of group of learners for any dangerous objects or illegal drugs if a fair suspicion has been established. Shall I continue, my justices?
That's fine, counsel. You can proceed. And for everyone who answers a question, you may proceed immediately after answering. You don't have to wait for a judge to confirm.
If you please the court, my justice. In the case of MEC for Education, KwaZulu-Natal and others, this is Pillay 2008, Section 1 SA 474 CC, the Pillay case, paragraph 98, it was stated, and I quote, "Both discipline and education are legitimate goals. However, care must be taken not to state the school's interest too broadly." My justices, it is clear that the code of conduct was adopted only to enforce discipline and to improve the school's reputation, regardless of what the Constitution states, regardless of what my client's constitutional rights are, regardless of my client's right to privacy, regardless of the Constitution, regardless of the law that governs us all, regardless of the law that protects our rights. But my justices, chapter 1, section 2 of the Constitution, it clearly states, and I quote, "The Constitution is the supreme law of the Republic. Law or conduct inconsistent with it is invalid, and the obligation imposed by it must be fulfilled." There is a clear contradiction between the code of conduct and the Constitution. And chapter 1, section 2 clearly states and clearly tells us that it is invalid if it is inconsistent with the Constitution. And my justices, in the Pillay case, MEC for Education, KwaZulu-Natal and others, this is Pillay 2008, section 1 SA 474 CC, paragraph 175. It was said, "The code of conduct, once adopted, did not contain any any express provision for exemption, either to regulate in what circumstances they would be granted or establish a procedure whereby exemption could be established. In my view, it is this absence which was a significant factor in giving rise to the unfairness of the case. My justices, it is clear that lack of an exemption in a code of conduct makes it unfair, as no learner, including my client, can provide a justifiable reason to come with a cell phone, and that can make them vulnerable to danger. And my justices, therefore, we as the counsel for the applicants, therefore submit to this. Yes, my justices.
Apologies to interrupt you again. Just so that I understand, is your issue that the school searches the bags of the children, or is it the fact that they search the bags as well as the fact that they don't allow the children to possess a phone, whether on or off? And if that is the case, if you have a problem with both things, do you have an alternative to suggest how the school can manage discipline without taking such measures as they did in the Code of Conduct?
My justices, may you please repeat the question?
Of course, counsel. So it's two questions. The first is, I would like to know, is just searching the bags the problem, or is it the fact that the school prevents the children from even having phones? Which is the actual problem that the court needs to address that infringes privacy? And second, can you give this court another solution that the school can take to make sure that there is some form of discipline and that the children stay off their phones as opposed to what they've done now?
My justices, the problem is that they searched the whole school, violating their rights to privacy, and their code of conduct lacked exemption, which led them to violate South African Schools Act as to how they can limit my clients and the whole school's right to privacy. And my justices, may I continue? We as the counsel therefore we as the counsel for the applicant concluded that since the respondent's code of conduct lacked exemption, under which learners would be granted, did not provide conditions and procedure under which learners would be granted exemption. We say the code of conduct is not only unconstitutional, but it is also unfair. My justices, I would like to argue further into the violation of my client's right to privacy and further show the inconsistency of the code of conduct to the Constitution. My client's right to privacy was violated when Mr. Mkhize saw. Yes, Mrs.
I'm going to disturb you one last time. I just wanted to know, does it make any difference that the students were aware that this was a rule of the school, that they couldn't bring phones to the school, but they still did it anyway? Does this make any difference as to the school's actions, the fact that your client openly knew of the rules but still went against them?
My justices, we say, since the code of conduct lacked exemption, lacked any alternative reasons for my clients to come with a cell phone. My clients did not have a choice but to come with a cell phone, as they did not know what other measures or what they could do in order to come with a cell phone, as they were not provided such measures as how they could come or when or under which conditions they would come with a cell phone.
Okay, thank you for that answer, counsel. I do see that your time has expired. If my co-judges don't have any other questions, I'm going to take their silence as acquiescence if they don't speak up. Then I will just grant you an extra 30 seconds just to summarize whatever you have left to say and conclude, please.
My justices, my client's right, not only my client's right to privacy was violated, also the respondents violated my client's right to basic education as they were suspended immediately without any educational content. And Section 29 of the Constitution, subsection 1, paragraph A, clearly states everyone has the right to basic education, including adult basic education. This means my clients have the right to be educated. This means my clients have the right to be given educational content to improve their knowledge. But they were not granted such, they were not given such content. My clients do acknowledge that Section 29 is subject to limitation, but South African Schools Act gives us a clear guidelines onto how to limit my client's right to basic education. And it says, if a learner is suspended, the governing body must conduct a disciplinary hearing within 7 days of the suspension.
I believe your time is up. Thank you. Thank you to my co-judge. We then call upon the second speaker of the applicant, please.
As the court notices my justices, I will be proceeding from where my co-counsel left off by turning to argue the fourth question before this court as to whether indeed the Mjondolo Combined Schools SGB's document referred to as the respondent is indeed unconstitutional and in violation of the learner's right to peaceful assembly as enshrined under the provisions of Section 17 of the Constitution of the Republic of South Africa Act 108, written and approved. Everyone has the right to, peacefully and unarmed, to assemble, to demonstrate, to picket, and to present a petition. Close quote. My justices, as it pleases the court, I wish to argue in detail the incident that has given a rise to a violation for the applicant's right to peaceful assembly in terms of Section 17 of the Constitution. The code clearly means that the applicants had the right to express their emotions and dissatisfactions, to assemble and unite against the unconstitutional rules and circumstances they were forced to follow and obey. The applicants were arrested in connection to an alleged illegal offenses committed on or about the 2 consecutive days of the protest by the learners at the school. The offenses committed includes an illegal gathering, the burning of the office block, and the being respective. More than 100 learners participated in the protest. However, only the applicants were arrested in connection with the fires that erupted during the assemblies. The respondent's selective suspension, not only per se, the respondent's selective suspension for the applicants per se related not to the assembly, but to punish those who are presumed the instigators of the assembly, even though evidence does not in any way identify them as culprits. The police report could not identify any culprits, which then brings me to this question as to why were they arrested if no culprits were found. My justices, if my clients were arrested for convening an illegal gathering, then that means that they were charged for not giving out a notice for not giving out a notice for the assembly. The notice was not necessary in this regard because the gathering took place continuously. To support my argument, I would like to draw the bench's attention to the case between Mulongwana and others versus Anara in 2018. The court declared that Section 12, Subsection 1, Paragraph 8 of the Gatherings Act is invalid and unconstitutional because it criminalizes those who fail to notify the authorities of their intention to protest. Therefore, we argue that our clients should not have been arrested for failing to submit a notice. The respondent's conduct violates the applicant's right to peaceful assembly, and it sends out a message that one shall be punished for leading a protest, for leading a movement, for standing up for one's right, silencing those who want to exercise their right to peacefully assemble. My justices, when the applicant's right to peaceful assembly was being violated, their right to equality was also violated in that the applicants were discriminated against as they were selectively suspended out of approximately the 100 learners that took part in the protest. My Justices,
Counsel.
we have
Sorry to break your word. I would just like to know from you, the children did block the entrance of the school to the extent that other learners were prevented from learning for the day until midday. Shouldn't they be arrested for this at least, the fact that they prevented other learners from accessing their right to education for this protest?
Well, my Justices, I understand that the school started violating the learners' right to peaceful education because they suspended them spontaneously after they found the cell phones.
Counsel, I have a question. So when you say that the school spontaneously suspended the learners, were the learners not supposed to have been aware of the code of conduct? Was it a spontaneous suspension?
Can you please repeat the question?
You said that the learners were spontaneously suspended, right? So my question is, was it really spontaneous if the learners were aware of the code of conduct? Were they not supposed to have adhered to the code of conduct for them to not be suspended? Was it really spontaneous, or they just decided to go against the code of conduct, which led to their suspension?
Yes. The code of conduct that was invented by the school, it oppressed the learners' rights.
Okay, thank you. Can continue. Thank you.
My Justices, we have transitioned from an unjust government that treated people unfairly and divided our nation. And now we live in a democratic society where everyone enjoys the same equal rights and benefits in the eyes of the law. The Constitutional Court, as an apex court in the land, is the upper guardian of the Constitution, with a heavy duty to uphold, to defend, and to protect the Constitution and the Bill of Rights of the Republic against those in possession of the respondents of having power to overreach their executive authority and violates the right of those under their authority, care, or guidance. It is unfortunate that some of the people occupying high positions misuse their power to oppress those who are helpless and powerless. These power-driven people are the same people whom we as the nation have entrusted in the protecting, the defending, and the upholding of our Constitution. If the people who are supposed to lead us don't do things by the book, lawfully as they should, then how do we as a nation supposed to follow? We cannot follow simply because of the lack of discipline from our leaders. Our leaders are supposed to be leading us, but they are the ones making a mockery out of our Constitution. My Justices, in closing our argument, we the Council for the Applicants have shown this court certain factors were not considered in great detail by the High Court on the point of law, in that Section 4 of the Mjondolo Combined Schools Code of Conduct is inconsistent with the Constitution and it should be declared invalid, and respondents be ordered to amend the Schools Code of Conduct. We pray this court to make an order declaring the respondents in breach of Bill of Rights, especially breaching the right to privacy, which was permitted by the principal, the right to equality when the applicants were discriminated against, and the right to access basic education by placing the applicants under a suspension that did not follow the correct procedure. We, the Council for the Applicants, finally pray to this Honorable Court to declare the suspensions of the applicants unlawful and set the High Court judgment aside to uplift the suspension of my clients so that they can return in class. The rest of the cases.
Thank you very much to the speakers of the applicant. We appreciate your submissions. I then call upon the speakers for the respondent to present before this court. The first oralist may approach the bench.
Greetings to the court, the Chief Justices, and the Honorable Chief Justices. My name, as I've said before, the question before the court is whether the SGP's decision is unconstitutional and does not violate the learner's rights.
Counsel for the respondent. There's music in the background. I'm not sure if it's yours.
Your
or...
Honor, there's a disturbing. Yes, and we alerted you guys in the message, so I think you were not aware.
Applicants, please mute your mic. Maybe it's coming from you.
Is the noise coming from your room, respondent?
No.
No, I think it's a background problem of the respondent. So it looks like
we don't have a radio.
We have to manage to listen to whatever they're saying. It's your background, right? It's coming from outside your place.
It's coming from the respondent's background because the applicants are mute.
Yeah, but it looks like it's something that the respondent don't have control over. It's like an environmental sound, if I understand correctly.
Okay. The counsel for the respondent then, I suppose you will just have to speak a little bit louder so that we can hear you over the music. So perhaps if you could stand maybe a little bit closer to your mic.
I think the young people today have shown us how they can really be actors of change when it comes to human rights literacy and advocacy.
Maybe they can move away from that
really
side.
a sense of renewed inspiration about the work that we are here to do in uplifting the Constitution of South Africa and the universal human rights values.
The question before the court is whether the SGP's decision is unconstitutional and does not violate the learner's right to peaceful assembly in terms of Section 17 of the Constitution of 1996. The counsel for the respondent submitted that Section 4 of the School's Code of Conduct is not unconstitutional and does not violate the learner's right to peaceful and basic education in terms of Section 14 and 29 of the Constitution. Section 4 of the School's Code of Conduct is unconstitutional as it states that the School's Code of Conduct is in line with the Constitution. Section 4 of the School's Code of Conduct states that the use of cell phones, whether on or off, by the learners on the school premises should all be times be.
I have a question for you. I see you have addressed this court on the substance of the code of conduct, and but beyond the code of conduct itself, the applicant seems to have informed this court that the procedural aspect of your client is not correct with respect to the suspension of the student. Can you please explain to the court how your client procedure?
Your Excellency, if you can repeat your question.
Okay, so I'm saying, can you explain to the court?
So, Your Excellency, can you please check our technician? We have a problem. I can't hear anything.
Okay, I'm just going to try.
Can you please check our technical problem first?
Does that help?
Yes, Your Honor.
Okay.
Thank you.
Counsel, I've paused your time. When the learned judge repeats his question, I will resume your time when you begin to answer.
Okay, thank you, Your Honor. If the court pleases, I would like to proceed.
My question is there now.
Okay. Please explain to the court how your client has followed the proper procedure in suspending the student. Your Honor, by implementing a code of conduct, it basically means that everyone should adhere to the code of conduct. So, Your Honor, by the implementation of the conduct, Your Honor, the learners and the parents were informed about the code of conduct, Your Honor. If you go back to the Mjondolo case, Your Honor, they received the code of conduct. They also signed the code of conduct, Your Honor. So, when you're saying the proper procedure, Your Honor, it was proper because they were alerted before that. After finding your phone, whether on or off, Your Honor, it's going to be confiscated. So, Your Honor, yes, the procedures were followed. Thank you, Your Honor. I don't know if you answered your questions correctly, Your Excellency.
Yeah, please proceed. It's fine.
The adoption of the code of conduct was in the best interest of both learners, educators, and also parents. In terms of the Schools Act, every school had the discretion or power to adopt or implement a code of conduct that is suitable for its needs. Section 36 of the Constitution of 1996, Section 36, subsection 1E, states that less restrictive means to achieve the purpose, Your Honor, which was to maintain discipline. So, Your Honor, I believe that the learners did not take that into consideration. They overused their power, Your Honor, according to our act here, Your Honor. They did not limit their rights, Your Honor, according to our Constitution. If the court pleases, I would like to proceed.
Thank you. Can you hear me now?
Yes, Your Honor.
So you said less restrictive means, and don't you think this suspension is a bit harsh? Couldn't there have been some less restrictive means to enforce discipline in this situation?
Your Honor, if you go back, they said according to our South African Schools Act, it states that no corporal punishment must be used. So, Your Honor, excluding corporal punishment, I don't understand which other punishment must be used, excluding punishing learners and excluding suspending them, Your Honor. So suspending them was a better way of punishing them without beating them, Your Honor.
So you think suspension is the least restrictive means that the school could have adopted in this instance?
Yes, Your Honor.
Okay, thank you. Please proceed.
Counsel?
Yes, Your Honor.
Do you not think that there could have been a distinction between learners who are found to be in possession or learners who are found to be using the phone with regards to the code of conduct?
I beg your pardon?
Could the distinction between learners who are using the phone during school hours and learners who are merely in possession of a phone not have been a less restrictive or a reasonable means in applying the code of conduct?
Your Honor, if we can go back to our section 4, Your Honor, it stated that whether on or off inside the school premises, it should be confiscated. So, Your Honor, I felt like if they had their cell phones, whether on or off, Your Honor, it was not illegal. It was not legal in the school premises. I don't know if I answered your question.
Thank you.
Counsel, I'm sorry. We are taking a bit of your time on this issue, but considering the fact that the limitation of the rights is supposed to, serve a legitimate purpose under Section 36 of the Constitution, don't you think the suspension here has sort of defeated the entire purpose of the right to education of the student when you suspend them and they can't come to school?
I beg your pardon, Your Honor.
So I'm saying, does the suspension serve any legitimate purpose now at this point in time, when you look at the fact that it means that the student will be totally deprived of access to school, which is an infringement on the right to education? Is your measure not supposed to serve a legitimate purpose? Does it look like a legitimate purpose if they cannot come to school anymore?
Your Honor, Thank you, Your Honor. Your Honor, if you remember well, by making that strike that they made, Your Honor, they also deprived other learners from learning. According to Section 29 of the Constitution, states that everyone has the right to education. So, Your Honor, by blocking those gates, they did not use their rights with responsibility. Your Honor, they also deprived other learners from getting access to education.
Thank you, Counsel. Please proceed.
The SGB's decision is constitutional. SGB had every power to suspend 6 learners because they violated the school's code of conduct. Learners' protest was not peaceful. They blocked the gate and the street with beams, which led to confrontation with the road users. And, Your Honor, they were also polluting the area. So, Your Honor, the applicants, Your Honor, they were not acting accordingly. They were supposed to write petitions, in what they did not do, Your Honor. So, Your Honor, in everything that they did, Your Honor, they did not consider the Constitution of 1996, Your Honor, which is the supreme law of our country. Your Honor, they alleged caused fire in the gate, which prevented other learners and educators from gaining access to the school. With that being said, the SGB was within its right to, when suspending the 6 learners. I would like to call up my co-counselor to inform the remaining factors. Thank you.
So before you leave us, sorry, just one last question, unless I can't see you, so I don't know if you've changed. But I just wanted to know, doesn't the school have to consult the learners and the parents, the SGB, before putting together a code of conduct? How is the code of conduct fair if they haven't spoken to the learners and the parents about it before putting it together? You can answer my question and then you can hand over to your co-counsel. You have a minute remaining.
Your Honor, if we remember well, Your Honor, they did receive the code of conduct. The parents signed the code of conduct, which meaning that they were aware of all the effectiveness of the code of conduct, Your Honor. I don't know if I answered your question correctly, Your Majesty. Thank you.
That's fine, Counsel.
Good
You can close.
Thank you. Good afternoon to the Honorable Court, the Honorable Justice, and the Honorable Chief Justice. My name is Unati, and I am the second speaker representing the respondent. If it pleases the court, I'd like to start. The school's code of conduct is in line with the Constitution. Section 4 of the school's code of conduct states that the use of cell phones, whether on or off by the learners on school premises, shall at all times be prohibited. Any learner found in possession of a cell phone shall have it confiscated. And this is Your Honor, it is justified because of the following facts. The academic history of Mjondolo Combined School was very poor. Therefore, the SGB, together with the principal, placed rules in effect. These rules were implemented to improve the quality of learning and making a conducive environment so that it can be easy, so that learning can learning can take place easily without disruptions that the cell phones within the school premises caused. The code of conduct was adopted and passed for disciplinary purposes. The prohibition of cell phones was not to spite the learners or deprive them access to communication with their parents, but rather was put in place to eradicate low attendance and to increase maximum participation amongst the learners. As the counsel for the respondent, we have established that before the implementation of the school's code of conduct, there was no order and there was a large medium of anarchy within the school premises. And since the implementation of the code of conduct, the pass rate of Mjondolo has drastically increased with a pass percentage of 72%. And there is discipline in the school. The aim of the school's code of conduct was to govern and maintain order within the school. Therefore, the adoption of the code of conduct was in the best interest of both the learners, the educators, and everybody who is involved in the education system. In terms of the South African School Act, every child, every school have the discrete and or power to adopt or implement a code of conduct suitable for its needs. And the code of conduct of Njondolo was indeed suitable for its needs. Furthermore, the learners' protest was not a peaceful or peaceful march, and because they caused great chaos within the school premises. Section 17 of the Constitution states that everybody has a right to peaceful assembly, peaceful and unarmed, to demonstrate, to picket, and to present petition. Therefore, the SGB decision is constitutional, and the SGB had every power to suspend the 6 learners because they violated the school's code of conduct. Yes, your Excellency.
What about the protest wasn't peaceful?
I beg your pardon, Your Excellency.
I would like to know what makes the protest not peaceful. What did the learners do that we can say that was violent or exempts them from this right?
The learners, they came to the protest armed. They closed the school entrance gate, and they burned beans outside the school premises, and therefore, in that sense, that caused a great disruption so that learning can take place efficiently.
But Council, we don't necessarily know who started the fires. Is just blocking the premises, is that violent in nature?
Yes, Your Excellency. Your Excellency, blocking the school, banning the beans, and stopping the people from gaining access to the school premises caused great chaos, and therefore that affected negatively how education or the way it's supposed to be. If it pleases the court, I would like to proceed. The SGB's decision is constitutional. The SGB had every power to suspend the 6 learners because they violated the school's code of conduct. They interrupted the school by blocking the gates, which prevented other learners and educators from gaining access to the school. With this being said, the SGB was within their rights when suspending the learners. In summation of our argument, as the counsel for the applicant, Your Excellency, as the counsel for the respondent, we have established that the school's code of conduct, it is not unconstitutional, and this SGB's decision, it is also unconstitutional. And I would like to stop here and reserve the minutes that we have allocated for our rebuttal.
I'm just wondering, is the respondent supposed to have a minute for rebuttal? Isn't that supposed to be for the applicant?
So in the briefing that we had earlier, we were told that the applicant may use up to 3 minutes for rebuttal, but I think our applicants have reserved 2 minutes for rebuttal. And the respondents may exercise the choice for rebuttal, but it may not exceed 2 minutes. So because the respondents have left a minute remaining, we will give them a minute for rebuttal in a moment. Okay, cool. All right, thank you for that, respondents. We'll then call upon the applicants to proceed with their rebuttal for 2 minutes.
As it please the court, my justices, we, the applicants, do acknowledge that the school's performance increased after the code of conduct was adopted. But at what cost? At the expense of my clients, which are the children and all the children in the school. rights, constitutional rights. But in my justices, section 28 of the Constitution states that the child's best interests are of paramount importance in any matter concerning the child. My justices, the respondent suspended my client without any educational content. That it is clear that they didn't have any best interest at hand when they suspended them. The code of conduct says, my justices, we also argue that the respondent's code of conduct could have had other measures than to suspend my clients from school, limiting their rights to basic education. My justices, my co-counselor will continue with the rest of the rebuttals.
As the court pleases, I would like to ask my learner colleague. She said that the conduct does not violate any of the learner's constitutional rights. When the applicants were suspended without a hearing, without educational content, doesn't that violate the applicant's right to education in terms of section 29 of the Constitution, as the only guideline to limit my client's right was not followed? And secondly, why were the applicant's suspension extended if no culprit were identified and no notice is needed to protest, according to Mlungwana and others versus another in 2018?
Okay, thank you, applicants. You did that with perfect time, but just for your rounds going forward, I'm not sure how you'll proceed from here, but normally we don't have two speakers doing rebuttal, only one speaker does rebuttal. You're not allowed to swap like that, but that's okay. I permitted it now, given that I don't think you knew that that was the case. Respondents, then we'll give you a minute. Please make sure that it's just one speaker doing your rebuttal.
Thank you, Your Excellency, for this opportunity. The respondent has established that the Code of Conduct is not unconstitutional and that the SGB's decision is not as unconstitutional as according to South African Schools Act of 84, 1996, Section 8, subsection 3 says that subsection 2, a code of conduct must be aimed at establishing a disciplined and peaceful and purposeful school environment dedicated to the improvement and maintenance of the quality of the learning process. So, Your Honor, the applicants were not aware of that rule after making everything that they did, the strike that they made and everything, Your Honor. So, Your Honor, I believe that they were very aggressive towards our constitution. I pray for the respondent to get justice, and you, my lord, whom I believe in, you will give them justice. Thank you.
Okay, thank you very much for that. I think with that we can close the entire proceedings. Thank you very much to the applicant and the respondent. That was excellent. I'd just like to ask before we dismiss everybody whether my co-judges would like to give some feedback or general comments to the speakers.
If I may proceed. So I think first of all, let me say congratulations to both teams. It's been a wonderful presentation and I really enjoy myself. So just a few comments here and there going forward. Hopefully you progress to the next round. So I think for the applicant, for the first speaker, you can save a bit of time by not really going too much into the details of the case, like the citation. So I see you spend a lot of time trying to tell us the exact law report, the paragraph, and all of that. What is really important is the substance of the case and how it applies to what you're saying. So So it's not necessarily about going into those technical details. I think you can save a bit of time from there. And I would also say for technical issues, you should pay attention to the screen. The presiding judge was showing you that it's time to stop, but you were just talking and it took like the intervention of the judge to tell you to stop. And for the second speaker, I would say, remember, it's supposed to be an interaction. It's a conversation. It was too obvious that you were reading. Yes, we understand you have to make a preparation, but try to also make it a bit interactive. So it's not exactly like you're reading out something to us. And I think I would also say that when you get a question from the judge, if you don't know the answer, you see, you can just use a simple yes or no and try to move on. I think for almost a minute when one of the judges asked the question, you just kept quiet and you switched off. So you can just navigate your way around that. And for the respondent, I would just say, when you want to answer your question, just go directly to your question. You used a lot of words like, Justice, if you remember well. No, it's not for us to remember well. Just, proceed straight to your answer. And when you also answer your questions, you also say, I don't know if I've answered your question well. I think this was particularly the first respondent. You don't really need to do that. Just make your answer, try to continue. If the judge is not satisfied, then the judge will probably probe further. But I think it's really been wonderful and it's really been interesting listening to you guys. And I wish you good luck in the next round. Thank you.
Well, with the feedback I was going to give, my judge already gave almost everything I wanted to say. There was a lot of reading from the applicants. And with the questions, yes, when you don't understand, just ask for it to be explained a bit further or just for it to be clarified so you can understand the question if you don't understand it. And yeah, for the respondents, the first speaker, you spoke too quick, but I was able to hear what you were saying. So otherwise, the whole thing of saying you don't know if you answered it correctly, yeah, you can stop doing that. Overall, thank you.
I think I agree with both of the judges. First of all, I just want to say well done, you guys. It takes a lot of effort, I know, to prepare, and then it takes a lot of confidence to bravely plead in front of 3 people who are asking you questions and worrying you while you're just trying to get through this thing. But it was really nice to have you guys interact with us and engage with us. But I just have a little bit of feedback despite your good performance. The first is that I really appreciated that you guys had cases and that you were telling us what the cases are about. But remember to keep that up throughout all of your arguments. Sometimes your arguments were a bit emotional. You tell us things about like leadership and that leaders should set examples, for example, but those aren't necessarily arguments that are based in law. So every time that you're saying something, make sure that you have a case or some kind of law so that your argument is more legal than it is anything else. But I think you guys did a good job with that. And I agree with what my previous judges have said, to just be confident and proceed once you've answered. But overall, it's been a very good performance. Well done to all of you. And I hope to see you in the next round. I think with that, if nobody has any other questions or concerns, I think we can close the proceedings. You may all leave the meeting.